October 2019, if it's been represented in the state's pleadings before that's when they met. Does that sound familiar?
If that's what they're saying, then absolutely. I know it was at a conference in 2000. I mean, it was at a conference. If you say it's 2019, I'll take you at your word.
Okay. So it was what you're sure of, though, is it was at a municipal courts judges conference.
Yes.
When they were both municipal court judges.
Yes.
So it's fair to say, since she became district attorney, she was no longer a municipal court judge. So it had to have been before that.
That they met?
Yes.
Yes.
And he was teaching a class at that seminar, as far as you know?
I'm going to object that's deleting at this point. That's no direct.
Was he teaching a class at this seminar?
To my knowledge, he was.
And was Ms. Willis, to your knowledge, attending this seminar?
Your Honor, I'm going to object. There's no personal knowledge. He wasn't present at the municipal court training.
So they put it in their pleadings. Like, we are going to be here all day.
We are going to be here all day.
All right. If you can establish that he would have some personal knowledge, then that's a fair question. So you just need to preface it with that, and that's fine.
Thank you. Are you aware of when their romantic relationship began?
Your Honor, I'm going to object. That relates to privilege. She says that he began representing Mr. Wade in 2018. He met Ms. Willis in 2019. That's clearly within the bounds of attorney-client privilege.
I think there's understood, Mr. Vadi. So I think, Ms. Merchant, you need to qualify that question.
Thank you. I'm not asking you to tell me what Nathan Wade told you in furtherance of legal advice. Okay, so I want to be very clear. If he told you something asking you legal advice, I'm not asking you about that. I'm asking about what you observed, what you saw, and what you knew outside of what he told you when he was specifically seeking legal advice. Okay?
This is too far afield. I apologize. I object again on behalf of Mr. Bradley. He's asserting that there's an attorney-client privilege associated with this case under Rule 1.6. For him to draw any inference, make any statements, or any other proper information after this relationship began between attorney and client December of 2018 would be improper, and he would in fact be violating the rules of ethics associated with his bar license.
So the way the question was phrased was just saying, what did he personally observe outside of the relationship, not involving communications? How does that fall within attorney-client privilege?
Your Honor, whether we like it or not, when we have a client, there are a number of items associated with that relationship between attorney and client that come within your purview and that lead you to further action, lead you to further investigation, further questions, develops your strategy. We can't talk about Mr. Wade on any level. It would be inappropriate. The divorce was filed sometime thereafter. During that entire interlude, any of these issues could in fact have been the basis for their relationship to remain privileged.
Ms. Merchant?